Good morning, good afternoon to India, good evening to Australia. Welcome at our next session. Since 25 November, Voices of Faith has been talking to different women religious, about the issues of violence, abuse, racism, sexism, discrimination, and human rights in the Roman Catholic Church. Today, we are looking at the collisions between two fundamental rights, freedom of religion and the prohibition of discrimination. I quote Eva Maria Belzer, she's a professor from the University of Fribourg in Switzerland. A collision occurs when different fundamental rights holders assert fundamental right claims that come into conflict with each other. This is the case, for example, when fundamental rights holders invoke freedom of religion to deny services to people on the basis of their gender or sexual orientation, or when fundamental rights holders demand that the state protect them from discrimination within religious communities. In other words, fundamental rights conflicts are not about respecting and protecting one fundamental right and one fundamental rights holder. Rather, several holders of fundamental rights face each other, each with their own fundamental rights claims. Because in these cases, values collide that the legal system and society alike regard as fundamental, the state is faced with the demanding task of deciding which fundamental rights claim should take precedence over another. So today is the question, can our speakers answer the question of how the state should behave when the claim of religious communities to respect for their freedom and the claim of women to realize equal rights clash? The focus is also on the question of what fundamental rights obligations are incumbent on state actors when dealing with religious communities that exclude women from important offices. Can the state maintain public law recognition of religious communities that provide different rules for women and men within their congregations and deny women access to certain ecclesial or religious offices, and thus religious dignities and power within religious communities? How should the state behave towards non-public recognized religious communities that exclude women and LGBTQ people from religious offices, or follow other rules that directly or indirectly discriminate against women? I introduce Dr. Astrid Lobo-Gayovala, my friend, really for a long term, has committed much of her time to throwing the spotlight on the challenges faced and posed by interfaith marriages, as she encounters them on a daily basis. Astrid is a scientist and a feminist theologian. We need to admit that gender discrimination flourishes in the church and stop clothing it in patriarchal traditions and specious theological arguments, she says. Professor Kathleen McPhillips is the woman for women, religion, the church, and the state. She has written and published extensively in the field of gender-based violence and institutional child sexual abuse. Kathleen's work on religious organizations also looks closely at the relationship between religious groups and the state and the various and common claims to religious freedom that are made. She edited an international volume on gender and religious freedom, which she hopes will draw attention to the ways in which conservative religious organizations use the discourse of religious freedom to embed gender patterns which often discriminate against women and gender diverse groups. She is also looking closely at how religious organizations act as a state within a state and have their own laws, rules, and ethics, and what happens when these laws contradict the laws of the land. We enter into the topic with very concrete cases in India and Australia. Astrid, are women who are discriminated against in their religious traditions able to turn to the civil state to redress injustices? And to what extent is the Indian judgment landmark or explosive nature of the judgment?
Thank you, Chantal. I'd like to start with some of the very interesting cases that have been, have come up in India, where women who are discriminated against in their religious traditions have turned to the civil courts for redress. There's been a wide variety of these cases, from exclusion from places of worship, as well as cases involving divorce, inheritance, female circumcision, and even excommunication. All of these cases have been interesting because while the primary reason for going to court was to fight for equality for women and demolish patriarchal practices and structures, they also drew attention to a wider issue: the guaranteeing and enforcing of the constitutional rights of individuals in the face of tradition and religious values of communities. I thought I'd speak about two cases involving entry into a Muslim shrine and a Hindu temple, as these have bearing on the Catholic Church's ban on the ordination of women. In the Arabian Sea off the coast of Mumbai, there is a shrine of a 15th century Sufi saint, and this shrine is known as the Haji Ali Dargah. It sees about 50,000 footfalls a day. Suddenly, in June 2012, the inner sanctum of the shrine was closed to women. A resolution unanimously passed by the Haji Ali Dargah Trust in August 2015 said that the entry of women in close proximity to the grave of a male Muslim saint is a grievous sin as per Islam. Noorjahan Safi Naz and Zakia Soman, office bearers of the Bharatiya Muslim Mahila Andolan (BMMA), a Mumbai-based non-profit organization that works for the empowerment of Muslim women, wrote to the Trust's president in 2012 and also approached various state authorities requesting intervention, including the Minorities Commission, the Women's Commission, and the Charity Commissioner. When nothing changed, the BMMA moved to the High Court of Mumbai in November 2014 and filed a writ petition challenging the Trust for the unreasonable discriminatory ban. They invoked the protection of Articles 14 and 15, that is, rights to equality and non-discrimination, and Article 25(1), which is the right to religious freedom. These are the articles of the Indian Constitution. Noor Jahan argued that the Trust's decision was a violation of the women's right to pray and gender equality, and that the Trust is only entrusted to manage and maintain affairs of the Dargah. It has no authority to impose any kind of restriction. The Trust responded by also invoking Article 25(1), arguing that Islam mandated the exclusion of women from the inner sanctum. It presented three main arguments to defend the ban. First, that women wore blouses with wide necklines which will show their breasts when they bow to pray. The second, the ban is a good thing because it prevents women from mixing with men at the sanctum, thus preventing sexual harassment and eve treason. And third, since the Trust members were unaware of the provisions of the Shariat earlier, now the ban is nothing more than an amendment. To mediate the competing claims of individuals, communities, and the state, the court used the essential religious practices test, something that has been coined by the Indian courts. Under this test, religious practices can gain constitutional sanction only if, in the view of the court, they are essential or integral to the religion in question. After examining the passages from the Quran and the Hadith placed before it by the Dargah Trust, the court found that none of this material supported the Trust's claim that Islam mandated the exclusion of women from the inner sanctum of shrines. Furthermore, the Trust was a public charitable trust Consequently, the dargah was akin to a public space and access to it could not be denied on discriminatory grounds. BMMA won the case in the High Court. Unhappy with this decision, the trust went to the Supreme Court, but the appeal was denied. And in October 2016, the trust was asked to make proper arrangements within 4 months for women's entry into the dargah. Today, women can once again enter the inner sanctum of the shrine. In another famous case, things have not gone so smoothly. Sabrimala, which is a famous Hindu temple located on a hilltop in Kerala and is dedicated to Lord Ayappa, who is a celibate, who is considered a celibate, a brahmachari. Here in 1991, the Kerala High Court restricted the entry of women above the age of 10 and below the age of 50, those that were in the menstruating age. In 2006, a petition was filed in the Supreme Court by the Indian Young Lawyers Association seeking entry of all women into the temple. 10 years later, the court questioned the ban, saying it couldn't be done under the constitution. After receiving review pleas, the Supreme Court referred the case to a constitution bench. On September 28, 2018, the Supreme Court lifted the ban on women's entry, but 5 months later, the Supreme Court reserved its judgment on pleas seeking a review. A year after the lifting of the ban, the Supreme Court referred review pleas to a larger 7-member bench. In the meantime, there is no stay on women entering the shrine. But women themselves are reluctant to enter the shrine, and activists attempting to enter the temple have been blocked and intimidated by protesters and even physically attacked. In early 2019, 2 women managed to enter the Sabrimala temple for worship. Following this, the temple officials temporarily closed Sabrimala to perform rituals of purification. The Sabrimala decision was met with severe opposition in the state of Kerala. Demonstrations and protests turned violent. Protests were held in both Delhi and Mumbai. The feeling was that the so-called secular government had failed to protect the religious sentiments of millions of India's Hindus. In consequence, a religious shrine has become a conflict zone. In the Sabrimala temple case, the 5-judge bench of the Supreme Court, by a 4:1 majority, on 28 September 2018, held that the temple's practice of excluding women is unconstitutional and subverts the ideals of autonomy, liberty, and dignity. It held that the practice violated the fundamental right to freedom of religion of female worshippers and struck down Rule 3B of the Kerala Hindu Places of Public Worship Act as unconstitutional. This rule allowed for Hindu denominations to exclude women from public places of worship if the exclusion was based on custom. The Supreme Court further added that it emphasized that physiological characteristics of women, like menstruation, have no significance or bearing on the entitlements guaranteed to them under the Constitution. It held, in fact, that the exclusion was a form of untouchability prohibited under Article 17 of the Constitution. Interestingly, the dissenting opinion in the Sabrimala case was delivered by the lone woman on the bench. She said that the court must respect a religious denomination's right to manage their internal affairs, regardless of whether their practices are rational or logical, except in cases of social evil like sati. She said issues which have a deep religious connotation shouldn't be tinkered with to maintain a secular atmosphere in the country. She stated that the state must respect the freedom of various individuals and sects to practice their faith, and that Rule 3B does not stand in conflict with its parent act. She also concluded that untouchability does not extend to gender. On reflecting on these cases, I couldn't help wondering how the Catholic Church would fare if Indian Catholic women took it to court over the ban on the ordination of women and women's exclusion from the governance in the church. The magisterian still insists that a priest must bear a physical resemblance to Christ in order to stand in persona Christi. Vatican authorities often note that Jesus chose only men as his 12 apostles, the model for the priesthood and for the foundation of his church. Moreover, Jesus' omission of the Virgin Mary from those ranks is taken to mean that women could be revered without being ordained. However, Most of the major Protestant denominations already ordain women and even have women as bishops and cardinals. What's more, in the Catholic Church itself in 1976, the Pontifical Biblical Commission voted in favor of the position that nothing in Scripture alone prevents the ordination of women and that it would not necessarily violate Christ's intentions were the Church to do so. In the face of this, what if Indian Catholic women invoked the protection of Articles 14 and 15 dealing with the rights to equality and non discrimination and filed a writ petition in the Indian courts challenging the Catholic Church for its unreasonable discriminatory ban on the ordination of women? Would the Catholic Church's arguments be strong enough to prove that the banning of women's ordination is essential or integral to Christianity? This is a question which I would like to leave open. Thank you.
Thank you, Astrid. So interesting, really. Okay, what is the situation in Australia? Stories of women in Australia. Stories of women in Australia who have no access to civil courts because of religious freedom.
Thank you, Chantal, and good evening, everybody. I wish to just start by acknowledging that I'm speaking to you from Aboriginal land, the land of the Awabakal people, and I pay my respects to the elders, past and present, and I pay my respects to anybody in this seminar who is Indigenous, and I recognise that the land that I live on has never been ceded. So yes, it's very interesting to listen to the case in India and reflect on the situation in Australia, which is slightly different. So what is really interesting is that both India and Australia are democratic civil societies. So we have a legal system that is set up to manage and deal with inequality and injustice. But in my work, what I found is that that inequality and that injustice has gaps in it. And the gaps are largely based around gender and gender discrimination. So for example, with the cases in India, there has never been a case in Australia of a group of women bringing to a civil court discrimination in a religious organisation, such as was described. The means for doing that in Australia is called through the human rights law and the Human Rights Commission. And there have been lots of cases that have been heard before the Human Rights Commission about gender inequality. And some of those cases that involve the Catholic Church in particular are where the Catholic Church has sacked women or fired women from their jobs because they are single mothers or because they are lesbian or because they're not married. So the issue here is that those cases that are heard before the Human Rights Commission are held in what's called camera. So we never hear about them. They're held in secret, not secret, but we don't know what the results are. And in Australia, the situation remains that human rights legislation, which contains a whole raft of legislations about prohibiting the discrimination of gender inequality, conflicts with the rights of religious freedom. And the state has not been very good in dealing with that and in managing that. In 2012 in Australia, there was a review of the human rights legislation, which currently allows religious organisations to discriminate on the basis of gender and sexuality. So conservative religious organizations make the claim that because of tradition, they are not able to include women in, for example, priestly leadership or ordination. That's definitely the case in the Catholic Church. So what happens is the state has allowed in this human rights legislation what's called an exemption. The state recognises that the Catholic Church is based on tradition. It doesn't contest that or challenge that in any way. It just accepts that and allows, through these exemptions, a series of inequalities to develop, not only where women cannot be leaders in their religious traditions, but also where the church is allowed to fire people or to employ whoever they want based on gender discrimination. And as Chantal was saying at the beginning, this leads to a contradiction. So the modern state, the democratic modern state, has at its heart the principles of equality and inclusion. And in particular, democracies are designed to look after minority groups. And it's often said that the quality of a democracy is how well they look after the minority groups. But in relation to religious groups, the state has just accepted that religions cannot be part of that civil relationship because of tradition. And the argument here is that the state is not really interested in having a conversation about what tradition is, and it just accepts the given account of tradition. Whereas, in fact, if you look closely into, say, the Catholic Church, you will find that there is a lot of contestation and argument about what tradition is. And Voices of Faith is one group that is raising these issues and problems very clearly. So in Australia at the moment, a bill is about to be introduced to federal government to be debated. That is called the Freedom of Religion Bill. And this bill is designed to protect people in largely conservative religious groups, which in Australia means Christian groups, particularly Catholic and Anglicans, in response to the marriage equality legislation which was passed in 2017. So this will allow people who do not agree with that bill or do not agree with that law of marriage equality to discriminate against LGBTQI groups and to engage in speech that is discriminatory, to not employ people, and to not give service provision to certain groups. So it's very, very contradictory and it's very contested. And it's really clear that here, the question of rights, of human rights, is about the rights of a very small minority of conservative religions. And what we need to see here is that women's rights in religious organisations are actually human rights, and that women need to be speaking up more about what is happening in this space.
Thank you both. I come back a little bit on this balance of the different rights. So if we look at the absolute content of fundamental rights, and these are based on human dignity, and which no state actually may surrender. We can say with certainty that the prohibition of discrimination is considered the sanctum sanctorum of fundamental and human rights. The prohibition of discrimination represents the intangible core content of legal equality. What constitutes the intangible core content of religious freedom? What is your opinion about this, Kate or Astrid?
Well, it's very difficult, I think, to define what is the core content of religious freedom. But I think it's interesting to see it again from the Indian perspective, because unlike Australia, there are a number of cases that come to court, which women have brought to court. And in India, it's a little complex because while we do have the Article 25, which protects the right to religious freedom, we also have many religions. And all of these religions, as Kate has already pointed out, are very patriarchal, and their laws, their teachings, etc., are all inevitably discriminate against women. Now, in India, the situation is complicated because we have what are known as personal laws. It's a very unique component of the Indian legal system. And these laws apply to certain classes of people based mainly on religion. So you have the Hindus, the Muslims, the Christians, the Parsis. And the intention is to respect India's multicultural society, which has different religious groups, each with their own faiths and beliefs. So Indian courts have taken on these personal laws with mixed results. So the most famous case in India was the Shabanu case, which was actually a turning point in legal reform. This happened in 1978. Shabanu is a 62-year-old Muslim woman from the Indian city of Indore, and she filed a case in the local court against her husband. She was thrown out of her marital home by the husband. They had been married for 46 years and she had borne him 5 children. And all she was doing was demanding maintenance under the Indian Criminal Penal Code. That is not the Muslim law, but the civil law. Soon after she went to court, her husband chose to divorce her under the Muslim personal law, and thereafter defended himself, saying that he had already paid maintenance for 2 years and that a divorced Muslim woman was not entitled to anything under the Muslim personal law. Now, his counsel was basically arguing that in issues like marriage and divorce, the Indian Penal Code could not override the Muslim personal law. Somewhat unexpectedly, the provincial court in which Shabanu filed her appeal ruled in her favor and awarded her a monthly maintenance of just rupees 25. So she appealed this decision in a higher court, asking for an increased amount, and this was granted to her. This time, Shabanu's husband appealed to the Supreme Court. And in April 1985, the Supreme Court again ruled in favor of Shabanu and ordered her husband to pay her maintenance along with legal costs. The decision was immediately challenged by conservative factions within the Muslim community. The General Secretary of the All India Muslim League proposed a private member's bill in the Indian Parliament that sought to deny a Muslim woman's right to seek maintenance under the Indian Penal Code. For some factions within the Muslim community, the judgment implied much more than simply deciding the fate of a divorced woman. They saw it as concerning the right of the Muslim community to practice their religion freely. In other words, the Supreme Court's ruling was taken as a reversal of the Indian state's commitment to secularism and a serious threat to the community. It provoked a conservative patriarchal backlash from within the Muslim community, leading to a situation where Shabanu actually finally herself petitioned the Supreme Court to retract the judgment. The government, headed by Prime Minister Rajiv Gandhi at that time, was most concerned about the loss of the Muslim vote bank. This concern led Gandhi to side with the Conservatives and accept the Muslim women's protection of rights and divorce bill that the Conservatives had proposed. The bill, which became one of the most controversial pieces of legislation in India's legal history, had the following statutes. It said that the husband's responsibility towards his wife should cease after 3 months from the date of divorce. Then, if after these 3 months the divorced woman was not able to maintain herself, then she should be maintained by relatives. If not, then it should be by charitable institutions. So, of course, this met with a lot of public outcry, particularly from women's groups. Now, the problem here is the prioritizing of religious community over all other collectivities. As religious leaders seek to unify their communities into aggressive political entities, they tend to become increasingly authoritarian and demand from their members an uncritical adherence to a fixed set of norms. Most individuals do not question this and see their membership in religious communities as a compulsion, a faith to which they are bound by birth and which they cannot leave. It is this lack of an exit option that provides religion and religious communities with an important means to perpetuate patriarchy. And this process of administering patriarchy through religion was seen in the case of Shabanu. In the end, she was the one who asked the Supreme Court to rescind its judgment, which was in her favor, because she was a Muslim first. Now, subsequent to this, there have been other cases. There has been the case of the triple talaq, which there's an instantaneous triple talaq, and here again, a woman went to court, Shayara Banu, and she asked that this be considered as unconstitutional, and a constitution bench comprising 5 judges from different religions set aside this practice by a 3:2 majority, and further directed the government of India to consider the views taken by the court in this judgment and lay down a proper legislation to regulate the practice of divorce in Muslim communities. There's also been another case of with regard to female circumcision. Okay, this was a petition that was filed under Article 32 of the Constitution, which allows individuals to seek redressal for the violation of their fundamental rights. And it was said that this archaic ritual, the petition argued, was carried out without any scientific medical reason and without any reference to the Quran, and inflicted atrocity, bodily pain, inhumaneness, and mental torture on innocent girls and women, the burden of which they were forced to carry for the rest of their lives. The petition also relied on the UN Convention on the Rights of the Child and the Universal Declaration of Human Rights, and urged that the practice is violative of Article 21, that is the right to life and personal liberty. Now, many of these cases have now been referred to a higher court. It should refer to a larger bench rather, and are now still, there still has to be a ruling on this. So this is just to say that, just to give you an idea of some of the cases, and it's that have come up, including one of which was with the Parsi community of excommunication, because when a Parsi woman marries a non-Parsi, she's automatically excommunicated, which means that she cannot go to the fire temple. What's worse, she cannot even go to the Tower of Silence, which is where the Parsis will, sort of dispose of their dead and where the last rites are performed. So that is why this, and also they cannot stay, for instance, in India we have housing complexes which are for particular religious communities. So she would not be able to stay in such a housing complex. So this case also has been brought by women, and it has been brought to the court, and the court ruled in her favor. So this is just to give you an example, to tell you that it's a very complex issue, and it is not easy to say what exactly would constitute, core values of this, shall I say, the question that Chantal asked, the core content of religious freedom.
Thank you. Kathy, maybe going back to Australia, which is based more on Christianity, also like on the Catholic Church. What is for you the intangible core content looking now to the Catholic Church? Or would you say maybe the exclusion of women from certain offices is a core content of the Catholic Church? So if we say, discrimination, the prohibition of discrimination versus religious freedom.
Sorry, I think with the question of religious freedom, I think the answer to that is that it's defined in context. So it is however the state is defining religious freedom that we understand it. And one of the things that is so problematic at the moment in Australia, and it's not just Australia, I mean, there are lots of other democracies that are trying to manage this as well. There have been significant court cases in Canada, in Germany, in France, in the UK, that have all been circling around. I mean, Astrid was talking about what's happening in India, but it's all circling around this question of the hitting up of religious freedom and human rights. So religious freedom is however the state defines it and how it is contested. And I think in relation to the Catholic Church at least, religious freedom is defined by the ability of the Catholic Church to maintain its separation from the civil state and to run its own law courts and its own moral discourse and its own organisations. And the problem in Australia, as with other democracies, is that the Catholic Church has two arms. It has its pastoral arm, which are parishes where people go to worship, and then it has its corporate arm. And the corporate arm includes, well, it's a very big corporation in Australia. It runs, Catholic Church actually runs over 90% of the social policy agenda for the federal and state government. It runs schools and it runs healthcare facilities, aged care facilities, disability facilities, and so on and so on. So in terms of civic power, it has a lot of power. Yet it enjoys these exemptions from human rights that other institutions do not. So it's a problem, and the civil state is not really interested in addressing this. It sort of pushes people into the Human Rights Commission courts, so we don't get these cases coming into state courts. Really, we don't hear about them, and it means that the Catholic Church is able to continually provide this justification that it has to continue like this because of its tradition. And in that way, it is acting like it's a state. It is a state within a state. It has its own laws. It has its own law courts, its legal codes through canon law. And it even has an international body, the Vatican. So it's very powerful in that way. And I mean, other religions are also powerful. The Anglican Church is also powerful like this. And the state, the civil state, accepts that religions can continue maintaining these kinds of practices, which really, at the heart of it, so many of them are about gender discrimination. If you look very carefully at the exemptions to human rights laws, so many of them involve women and LGBTQI groups. So the state is not innocent here. It's not neutral because it doesn't critique and challenge the Catholic Church on its patriarchal structure. It must accept that it has some responsibility here in allowing women to be continually marginalised and isolated. But that the state doesn't do that. And because it doesn't, it's in this continual contradiction. And when you get a bill like the current Religious Freedom Bill going through Parliament, that's when it really we see that it's a really important time, because we're just seeing how conservative these religious groups are, and how much their idea of human rights are very much based on what we call patriarchal rights. Yet I think the population in general is probably quite disinterested in this, and so there hasn't really been much pushback against the church to explain itself. Even it's helped a lot by the fact that quite a number of politicians are conservative Christians, including our Prime Minister, who supports this religious freedom bill, and does not see the contradictions embedded in it.
Thank you. So you were saying the state is not neutral and there's no pushback. What I'm asking myself already for months, maybe even longer, what about the citizens? What about the Catholics themselves? You know, if we look at us as responsible citizens and in civil society with all the rights and duties that go with it in terms of emancipation and participation, so they are free in their religious, ideological, and political convictions, as well as in their choice of profession and way of life. But in the church, it's all different. There is this Marianne Heimbach-Steins, she calls this personality split. There is this vertical schism between the hierarchy and large parts of the faithfuls that must be abolished, she says. So the lack of enforcement of all human rights within the church, even more than 50 years after the Second Vatican Council, you know, there is no enforcement of these human rights within the church. Could we conclude that the majority of the faithful can apparently live quite well with the solution of a different outside and inside regarding human rights? Astrid?
Sorry.
Katie, sorry.
I'll just jump in because I wanted to say that I think that's a really good way to say it and to express it. I think that first of all, when we talk about the church, we're often talking about the church leadership rather than the general church body. And if you only need to dig a little bit to see that this whole concept of tradition and what is tradition is actually very contested. There is a lot of disagreement among Catholics, and they are a very broad spectrum of people. And in Australia, we have just had a synod, a plenary council, and although that was very heavily constructed and policed by the bishops, there was a lot of very heartfelt contribution by the laity to that, and the reform groups of the church were very active. And that was really good to see that there is this really big, diverse body of people with a lot of opinions. But the reality is that you're right, Chantal. If you belong to a religious tradition that has specific issues about gender equality, it's a problem because you also are living in a civil society where the state is protecting those rights, ever more so as these new laws are passed to protect LGBTQI, trans people, to protect employment, to protect service provision, to allow same-sex marriage, etc., etc. This is where the democratic state is going. So it's totally, I think it's a very good point to make that it does put believers in this difficult position. How can they be, on the one hand, contributing members of civil society and the laws of civil society that say gender inequality is wrong, yet practice in a church where the doctrines and the beliefs are daily proof of otherwise. And I think that's why there is so much discontent amongst people in the Catholic Church at the moment.
So, yes, I would agree with Kathleen on that, with you and Chantal, that, it is problematic, and you feel almost schizophrenic when you are, functioning in the church as women. What I want to say is that in India, what happens is that Catholic women tend to live in two worlds, the church and the state. So when they are in the church, they will accept without question that the church is governed by canon law and that the state is governed by civil law. And the church is all about receiving the sacraments, going for mass. They see it only as a religious institution. They do not see the church as a social institution. And I think it's only when the clergy sexual abuse scandals broke in the West and courts started taking up these cases and legal action was taken against the clergy abusers, no matter how high placed they were in the hierarchy, that women suddenly woke up to the fact that the church is not just governed by canon law, but also by civil law. And now in India, we have two laws which, thanks to the awareness which has been created by activists, we now have two laws addressing sexual abuse. One is the Protection of Children from Sexual Offences Act 2012, known as POCSO, and the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013, referred to as the POSH Act. And these two laws, according to me, are very important for us because of the implications with regard to the church. So when sexual offense of a minor occurs, every person who suspects or has knowledge of a sexual offense being committed against a child has to report it to the local police or to the special juvenile police unit. Because the act not only punishes the perpetrator of sexual abuse, but also penalizes those who have failed to report the offense. And they are penalized with either imprisonment or a fine or both. So when abuse of a minor occurs, heads of Catholic institutions or bishops can no longer hide such offenses when a priest is involved. The power to do so has been taken out of their hands by the state. The second is the POSH Act. Now, the POSH Act has excellent definitions for sexual harassment, as well as it defines the workplace in a very broad way. And here it makes it mandatory for any employer of a workplace with 10 or more employees to constitute an internal committee. And this committee is responsible for hearing and redressing any complaints pertaining to sexual harassment in the workplace. So all church institutions that employ more than 10 people have to, or they will all come under this act. They have to have these internal committees. The internal committees, you have a presiding officer who has to be a woman from the institute, two other members from the institute, and one member who has to be an external member from an NGO or any association which is working with the the cause of women. And at least half of these total members should be women. So this is very important because now it is no longer left in the hands of the church, but the state has in effect forced the church to take a certain action. The second point that I want, just two other points that I want to make. One, which is of course what Chantal was referring to, the whole question of clericalism in the church, that where we are, women treat the priests like gods. I have seen women actually kissing the hands of young priests on any Sunday, and they believe everything that father says, and use titles like Reverend Father, Lordship, Excellency, Eminence, Holiness. All of these are considered the norm, and this sort of widens the gap between women and the clergy. And the faithful are also discouraged from speaking against a priest in public. Even when sexual abuse takes place, bishops have been known to put the image of the priest and the image of the church before the quest for justice for the survivor. And sometimes priests and bishops are so used to this power that they seem to believe that they're above the civil courts. And this happened recently in a case of a land scam with Cardinal Alan Cherry, of the Catholic Church. And, he argued that being the head of the church, only canon law and not common law was applicable to him for transferring church property. And of course, the court immediately sort of came down heavily on him and said that the cardinal was not beyond the law, and they subsequently ordered a very detailed probe. And the last point that I want to make is that India is a little has a very special position at the moment, because India, as you know, has many religions, and at the moment there's a very difficult political situation where right-wing elements have actually been, attacking churches, attacking Christian communities. And so what happens is that there are anti-conversion laws which exist in a number of states, and so, on the one hand, there is the need for the community to stand together. So people don't want to be seen as, attacking the hierarchy or attacking a religious authority. But at the same time, you want justice within the church. You need to come out. You need to go to courts. Although, as Kathleen has already pointed out, that courts are not always neutral. So yes, so we do have this problem. So this is a kind of a tightrope that we walk, where we are on the one hand fighting for justice, and even encouraging women to approach the courts for justice, but on the other hand, you're also worried about how these things will be politicized by right-wing groups. So yes, so this is our situation in India.
Beth, you wanted to add something?
I did. I just wanted to say that I think the child sexual abuse crisis has brought to our attention, like nothing else, the issue between the secular state and religious organizations. Because what the Catholic Church was doing was, first of all, not reporting perpetrated priests and brothers to civil authorities. So they weren't reporting them to the police. They were kind of managing it themselves and keeping it quiet. And it was a disaster for everybody. But once there was a very big public inquiry in Australia from 2012 to 2017, the Australian Royal Commission into Institutional Responses to Child Sexual Abuse. So it ran for 5 years, and the Catholic Church was the worst offender. So most of the cases at this public inquiry involved the Catholic Church. And it came out with a series of recommendations. And Virginia, I'm just kind of responding to you here a bit in your question. It came out with a whole series of recommendations. And the Catholic Church, they didn't, it's not true that they ignored the recommendations. They didn't ignore their recommendations, and they set up a number of bodies to deal with responding to the changes. And what the Royal Commission was saying was that it had to be significant cultural change in the Catholic Church. Women had to be elevated so that the leadership pathways were open to them. Clericalism had to be outlawed, etc., etc. But as far as I can see, what I think has happened is there's been a lot of rhetoric and very little cultural change. And the reason for that is that the leadership of the Catholic Church is basically an old white autocracy or oligarchy, and they are in effect investigating themselves. So they're not going to be open to change, and they certainly haven't demonstrated that. But the state did come on board, and they've instituted a whole series of recommendations across schools, and they even for the first time entered the parish level, where they indicated that if a child was to report, or anyone was to report child sexual abuse in the confessional, then the priest had to, by state law, report that to the police. And as a body, the Australian bishops have come out and said they will not do that because of the sanctity of the confessional. The other thing is that, as you were saying, Astrid, it is now illegal to protect someone who has been involved in any kind of child sexual abuse. So those responsible who weren't directly involved but knew about it can be charged with the offence. So I think it has kind of split this relationship between the state and the church, that comfortable relationship doesn't exist anymore. And it's a really interesting time because child sexual abuse has been the big issue that has really done that. And when we're talking about the sexual abuse of vulnerable adults and of nuns, I think this is also part of what we're seeing here is the delegitimation of the Catholic Church across the globe. It no longer can be the moral voice that it once was because it has been it's been so problematic in its terrible treatment of children and women in particular.
Maybe my last question to you. We look at the Catholic Church and we know the fact is that 0.01% we call leadership, male leadership. And like you were saying, male, white, old leadership. And still all the rest of the faithful running around like sheep with this double morality, you know, outside democratic citizens, inside, I don't know, submissive people. What can we do to change this fact? You know, there must be some, you know, it must be boiling in all our stomachs that the Roman Catholic Church is violating human rights. So it must be boiling, but how can we stop this co-clericalism attitude or submissive behavior of the church actually, and not so much of kind of focusing too much on this very, very small percentage of male leadership? What can we do? What can Voices of Faith do to raise more the issue on human rights in the Catholic Church?
I think events like this, Chantal, are very useful, where you have people from across the world, you know, who are coming together, and you share ideas, you share, you know, you share views, and I think in our own ways also, in different, at least in India, I know there are a lot of groups which are now coming up where we have a lot of all these meetings, people who are very active and you know, trying to create awareness about these issues. But yes, it's going to take a long time because this clericalism is so heavily ingrained in us. It takes a long time to, you know, first of all, recognize the conditioning. I think the first step is that, to be able to recognize how we are conditioned, how we are manipulated, how we are imprisoned. And that takes time. And I think that can only happen, at least the way I see it, that can only happen when people dialogue and when you have, you know, events like this, sessions like this, where people are able to look at alternate ideas. Also, I think COVID was a good thing because COVID got us, in a sense, a little bit away from the clutches of you know, the institution. And women really were very creative and reinvented the whole idea of what it means to be community. And suddenly we have faith communities which are bridging, you know, cities, states, countries, which is great. So there's a, you know, a cross pollination of ideas, and also I think a whole what shall I say, a movement of solidarity. So, you know, you're beginning to realize that, hey, we're all on the same page. You know, we're hurting from the same things, and we are protesting about the same things. And I think this helps.
Yeah, I mean, that was really well said, Astrid. I mean, I agree with that. And I think also we have to remember that the Catholic Church is not a democracy and will never be one. Well, not while it's organised as it is. I mean, and so because it is such a patriarchal hierarchy, you know, less than 1% of all Catholics in the world are clerics. Yet that very small number have so much power in relation to law, structure and culture. So it makes it just a very difficult space in which to enact reform and change, because the ways in which we would traditionally do that through a democratic state are not open to us. So we have to be inventive and find creative ways. And I think I feel very buoyed by the work that I saw that was happening at the Plenary Council in Australia. The reform groups are very articulate and they have a very strong case. And the bishops cannot ignore that. So I think at that structural level, the bishops are having to answer these questions. And I think more at the parish level, yeah, I think the problem with the parish level is that it is becoming more conservative because people who do not want to be part of that are just leaving, or they're not, contributing at all. But I also agree that I think Voices of Faith has been a fantastic space in which to reimagine church and to fight for some of these really important issues about gender equality and human rights, and to bring to our attention some of the really terrible abuses that have been happening. And I think the more we do that, the better, because that is what the clerics are trying to keep quiet. And they're trying to keep quiet because they want to protect the reputation of the institution above all costs, even the safety of women and children. So that is what our sort of charge is at the moment, is that we have to make sure we can tell these stories of abuse and inequality. And yeah, I guess the challenge for us in Australia is to find ways in which to make the civil state aware of the contradictions of allowing religious organisations to have these freedoms, and the costs of those freedoms to women and to LGBTQI groups is huge. So they're very restricted freedoms, and they protect the rights of the patriarchal church. So yeah, I think we have a way to go, but I think it's teetering and it's all up in the air, and I think it's a great place to be, really.
I just wanted to add to what Kathleen said, when you talked about the church is not a democratic state. I think somebody has put on the group, if you say that it will never be democratic, it will never be democratic. And, the problem is, I find that you compare it to let's say, apartheid, in South Africa, you had, a very small community which was ruling over a large one. And the thing is that the policies, the teachings, the law, canon law, I mean, who made canon law? The people in power. So, we are held accountable to something which has been written by the people in power to keep themselves in power. So how do you fight this? I'm not quite sure I have an answer to that.
Thank you. Susanna, do we have questions?
We have a serious discussion here in chat about how to help LGBTQ people to talk honestly in their communities about their sexuality. We have some questions that Kathleen and Astrid already responded to in the meantime. And we have one question: how has official church responded to these expositions of abuse and injustice by Voices of Faith? I think this is the question for future, how they will respond or whether they will not, I guess. And also we have a voice from Virginia recording the case of George Pell, and what his case is saying about the relationship between justice and church and states in Australia. I don't know, Kathleen, if you want to comment on that.
Well, George Pell got exonerated from his abuse because he went through the civil court system, the criminal court system, and he won his appeal. But he was in jail for 18 months prior to that. What's really interesting, I think, well, there's a lot of interesting things about that case, was that once he was released, he wasn't long in Australia before he went back to the Vatican, where he has maintained his position of authority and power. So that gives you a good idea of what the Vatican thinks of Australian civil law. They're sort of the Vatican's track record on understanding and managing child sexual abuse is appalling. And so is the Australian Church. But yeah, I mean, I think George Pell's a very influential person. And the other thing that was really interesting was that when he was going through his court case, the people who came out to support him were other very high-ranking white men, basically. So that gives us an idea, not just of the individual, but of the status of church leaders in Australia. They have a lot of status. So that's why I say the civil state is not innocent here. Like, it is actually encouraging the way that the church operates, and we have to keep critiquing that. And I guess the way that I do that is through my research. I just see it as a really, really important thing to keep critiquing the institution and understanding how the institution works. And I think the other thing is that this is just in Australia, but in other countries where there have also been public inquiries into institutional child sexual abuse, the Catholic Church again has been often at the forefront of that. In the UK, there was a special hearing on the Catholic Church and also the Anglican Church, so and the US as well, etc., etc. So I do think that the child sexual abuse crisis and the sexual abuse crisis in general is probably going to be the downfall of the current Catholic Church, of the way it's organised at the moment. What will emerge from that, I'm not sure.
Thank you so much. I guess that's all from the chat.
Thank you, Susanna. Astrid and Kate, you have the last word if you want. Otherwise, we are slowly going to end this session.
I'm good, thank you.
You're good?
Yes, I hope that we can put pressure on the hierarchy, the people in the Vatican, to look at the church as a social institution which is subject to human rights. The charters and the declarations that already exist and govern the rest of the world.
Yeah.
Yep. I couldn't say it better. I think, Astrid, it is a social institution with histories. It's not a mythical institution with this kind of tradition that cannot be challenged. And the work that we're doing is constantly bringing that to people's attention. So I think the more we do that, the better. I think it's a great point to finish on. It's a human institution, social institution.
Thank you. And the discussion will go on. On Sunday, 4 young women will speak on discrimination in the Catholic Church, and on Monday evening, a bigger panel from Germany will also address the human rights issue. Thank you, Astrid, Keith. Thank you so much for speaking out and speaking up. We have to do that. Thank you.
Thank you.
And we see us again. Thank you.